friend that she was in the car with, went down the street and shot Christopher Linder and killed him in front of his mother and his own 2 minor children. Ensuing from that was a tort claim, which was filed by my office, or which was brought by my office. Claim then commenced after Miss Jacqueline Hall Johnson, the widow of the shooter who went and killed himself, barricaded himself in the house and killed himself on that same day. We moved to have her appointed as administrator ad litem for the sole purpose of receiving service in the tort action. Now that's important because this appeal essentially has 3 separate issues, 2 of which this court is able to review de novo, the 3rd under an abuse of discretion as standard. So the first issue is Jacqueline Hall Johnson, as administrator ad litem for the state of Kevin Ray Johnson, is she the proper party to this action for declaratory judgment? So we file the lawsuit. We have the order from the chancellor who says for the sole purpose of receiving service in the tort action.
Counsel, was this issue raised before the motion to alter or amend in this case? In any kind of written filing before the court? Or is the first time this was mentioned in a written filing was in the motion to alter or amend?
It was raised in argument at the motion to set aside default.
Was there an argument developed, or was it just noted? And was there actually an argument advanced that we don't have the proper party, the court should decline here because we don't have the proper party? Was that argument developed during the oral argument in this case below, or not?
I believe so. Looking back at the record, I believe at the end, the exact, not verbatim, but the essence of the argument was asking the court that we said we do not believe Ms. Johnson to be a proper party, and that if the defendant, because we didn't know if they had some order appointing her as administrator ad litem, and we asked for proof of that before the court made their ruling. And then Judge Thompson, I believe, said from the bench that I'm sure they will provide something. And that would be in the closing sentences of the trial court's, the transcript from the trial court hearing. That's volume 2, I believe, of the record. So that's the first issue for the court. You know, we haven't received any notice that she was appointed any separate than that for purposes of receiving service. She was not insured. She was not on the insurance policy that is subject of the deck action.
Doesn't she fall within the definition of insured under the insurance, though? I mean, it seems to me the insured is defined as including a person who is a resident of your household who is either related to you by blood, marriage, or adoption, your ward, or your foster child. Wouldn't she fall within the definition of insured?
I mean, I've seen that vary from policy to policy. And
if that's in this policy, would she fall within the definition of insured then?
I'd have to know more facts as to their exact situation at the time of this to give a definitive answer on that. But from that language, she was married to him at the time of this incident, but she was not specifically listed anywhere on the policy herself.
But if she's defined as being insured, then correct, she would qualify as insured under the policy. Correct,
but we're not dealing with her negligent acts. This is the acts of her husband, who was insured on the policy, who is deceased at the time of this incident. So that's prong 1. We do not believe that she is a proper party. Prong 2, and which is where the court spent most of its time, is dealing with the service issue. Now, Judge Bain, I believe in 2021, you authored an opinion on 300 Kate Street Partners versus NIS Trading, and that kind of had a similar, you went down the similar arguments in the law, except that was a service by mail issue. In this one, we were dealing with this agency issue or someone authorized to accept service on Ms. Johnson's behalf. So the testimony before the trial court from the deputy was that he had left a card, called Ms. Johnson, and she said leave it with someone at the residence, James Johnson. So on cross-exam, I asked the officer, deputy, if he had did he get any identification? Could he describe this person to me? The problem is that James Johnson does not exist. It is not a person. There's no one named James Johnson that I'm sure there is somewhere, but in relation to this incident, there's no one, a relative named James Johnson, nothing like that. Everyone the people living with her at the house, I believe, was a brother and her young child. There's no way, this is an instance the same as if the deputy had said left summons with John Doe, because we don't know. I can't get James Johnson up here to say, yes, I was authorized to receive service on her behalf. What Ms. Hall Johnson's affidavit says, and what she testified to court, is that she does not know a James Johnson and did not authorize anybody by the name of James Johnson to accept service on her behalf. The deputy's summons says served by phone, left copy with James Johnson. That's what it says. And we believe on its face that it's not valid service. Now, both sides have pointed to the Watson v. Garza case, and I think that goes into a similar situation. But the defense counsel is right, or the appellee's counsel is right, in that it's a little bit different because in that case there was a co-defendant and there wasn't any phone conversation. So it's a little bit different, but I do not believe that we should have to prove through any, and the trial court didn't necessarily find this, that we should have to prove through any disinterested witnesses as to any agency relationship between Ms. Johnson and the alleged James Johnson. In this case, we just can't, there's no disinterested witnesses because that person doesn't exist. Ms. Johnson testified before the trial court. She had to take a break during her testimony because understandably she was reliving this incident, how it happened, the events surrounding it, the events thereafter. Very traumatic for her, being shot by her husband, who then takes his own life. She did not remember any such phone call with the deputy. She wasn't going to call the deputy a liar, but she just said, I don't remember any phone call with that deputy.
Why isn't the trial judge then entitled to believe the deputy here? I mean, the deputy said, we had this phone conversation, this is what she said, this is who she said I should leave it with. I showed up at the house. This person identified themselves as under this name, and I handed them the document, and here's my note that that's what occurred. Why isn't the trial judge entitled to believe that testimony?
I mean, the trial judge is entitled to believe that testimony, but we believe, I mean, it kind of puts us in a difficult situation because Ms. Johnson saying she never received the complaint, she doesn't know anybody named James Johnson, and that she did not have any knowledge as to the motion for default that was filed shortly thereafter. So,
isn't that matter of credibility determination for the trial court? I mean, her memory was faulty, given the circumstances, understandably so. And here there's countervailing testimony that that's exactly what happened. And isn't that really just a credibility determination by the trial court?
Well, and I think if you look at the testimony from the officer, he also doesn't recall anything about what he looked like, any identification, any incidents surrounding it. They asked him about, was there any traffic that he's like, I don't know. And that's understandable too for the officer. So, and just because I'm running out of time, but if the court finds that she's a proper party and that she was and service was proper in this case, you know, we get into the abuse of discretion standard when it comes to evaluating the Rule 60.02 motion to set aside default. The law says that these motions are to be viewed liberally and that they should grant application whenever there's reasonable doubt as that default judgment should be set aside. We don't feel like we got that in this case. It was almost bending over backwards to close the case out and grant default. The court is well aware of the factors to set aside default. I'm not going to go into that, just the willfulness, meritorious defense, and the prejudice. But going to those factors, determining default was willful, they're saying that default was willful because the counsel for Tennessee Farmers filed an affidavit saying that she had called and left a voicemail. Here's my notes from the voicemail. We don't have the voicemail itself. She called and spoke with my assistant. Here's what my assistant said. She said, I'm objecting to trial court saying that's inadmissible hearsay, and that was another reason for our motion to alter or amend, and the trial court never made a ruling on that argument. So during this time, it's important to understand
what was your client's meritorious defense?
Her meritorious defense at the time, Your Honor, this involves, and I filed, it's a unique situation because I filed the circuit court, the tort action against the estate. That tort action does not plead intentional acts. Ms. Johnson testified that he entered in the trial volume 2, testified that he entered a state of psychosis. He wasn't himself, issues of medications. He went out and shot these people. Now, the policy in question says it should be excluded based on notice and based on it not being an accidental incident. I think his intent plays a large factor in this case. We pleaded negligent infliction of emotional distress for the 2 minor children in watching their father die in front of them, and the mother in watching her son get shot. Those torts aren't intentional acts. That we believe, on the face of that complaint, which is part of the record as well, that is a meritorious defense in this case. And lastly, the prejudice. There was no finding of prejudice. The court just said that the plaintiff would undoubtedly be prejudiced if this was overturned. They don't say how, they don't say why. The only thing in the record is a statement from counsel saying that is in terms of cost. Well, the courts have been clear that, and then in their brief they say the passage of time. But the courts, the Henry v. Goins case, I believe, says the fact that a party has to proceed to trial or the fact that a length of time has passed is not basis for prejudice in evaluating that third prong. So we believe, again, just finishing up, that the first 2 prongs should be overturned under one of those bases, and you don't even get to the third, and we believe the record shows that. Thank you, Your Honors.
Thank you. Thank you, Mr. Fisher. Mr. Dix.
Good afternoon.
Good afternoon.
May it please the court, I'm Steve Dix of the Rutherford County Bar, and I represent the appellee, the Tennessee Farmers Mutual Insurance Company, in this matter. Here to respectfully request this honorable court to affirm the ruling of the trial court. It comes to you with the presumption of correctness. It's really a straightforward matter. I kind of enjoyed I wonder if we could get CLE for listening to the divorce cases that preceded us. This one is a little more simple. The underlying case is, of course, I call them DEC actions, a complaint for declaratory judgment, seeking a ruling of no coverage for the actions of Mr. Johnson. She was served. I appreciate the court's question about is the trial court entitled to believe the deputy, and that's actually addressed in the Garza case, the Watson v. Garza case that we both cited, that they are entitled to presumptive weight because the deputies can't be expected to retain independent recollections. In this case, Deputy Thompson and I visited in the courtroom. This is not in the record, but he remembered going to the house twice. And maybe it actually is in the record, because I asked him, why do you remember going to the house? And he said, because I almost got run over backing out of Ms. Johnson's driveway. He remembered being there twice. He remembered knocking on the door. No one answered. He left the card. She called the number on the card. He says he spoke with her. She directed him who to serve the papers to, and he went back, knocked on the door, and someone who said they were James Johnson accepted the papers. He noted it on the summons. In a perfect world, would I have preferred that Ms. Johnson herself answer the door? Absolutely. But I do think it's proper for the proposed defendant to designate someone to accept service on their behalf. And that was the distinction that I made from counsel's brief in his reliance on the Garza case. In that case, it was a co-defendant saying, serve him. In this case, she is the one who said, take it back and give it to James Johnson at the house.
Counsel, in terms of taking one step ahead from where
Yes,
you're
sir.
at now, with regard to the willfulness determination in this case, is it problematic that the trial court is relying, at least in part, on the essentially Tennessee farmers' notes on, we got this phone call, here's what was said? Is that fair game? Is it not fair game?
I didn't know how to share what I knew. I wish I had now recorded and had transcribed by a certified court reporter the actual voicemail message. That would eliminate most of today's discussion. I thought I was being as candid as I could be. If you notice, I redacted my notes. I did not take her call. It is my practice in my office never to accept a phone call from someone that I know I'm going to be adverse to. So she was actually directed to leave me the voicemail message. I played it. I did my standard notes, handed it to my assistant. I'm sure it would be very similar to like when litigants try to call in and try to reach a judge. You're not going to take that phone call. You're going to screen it through your assistant or administrative assistant. And that's what I did in this case. Had my office manager attempt to call her. They finally hooked up. And then the rest of it was just further evidence that she knew what was going on. I never directly spoke with her. I respect now your question, is it problematic? I mean, I guess in theory I could disqualify myself and make myself a witness, a witness to it, but
Was there the motion to exclude any reference to that as part of the determination as to willfulness? Based on hearsay,
no,
so there was no motion to exclude that?
No, I think it came up, it might have come up in discussion. We argued this actually twice, and this goes back to the point of deferring to the trial court. Mr. Fisher and I appeared, and it was lawyer talk. I mean, we argued the case in front of Judge Thompson, and he was intrigued enough to say, I want to hear some proof on this. I'm going to reset this. And so he reset it. I think he gave us some time to do some additional briefing. I called up Deputy Thompson, and I told him what was going on, and I said, I've got to subpoena you. Hopefully it was a friendly subpoena. He didn't seem too upset. I got him off of patrol the morning of the hearing, but I told him I needed to put him on to explain his notation on the summons. That then dovetailing with everything that transpired since then. I mean, as an officer of the court, I mailed her the motion for default, the amended motion for notice for the hearing, not even withstanding the original correspondence where she indicated she didn't oppose the motion. I even prepared an agreed order and sent it to her. None of those were returned and presumptively delivered, and we've used the same address, and I think she confirmed at our hearing that was still her address. I've learned that some people don't like getting mail and they prefer email. So I had my assistant secure her email address. She confirmed to me on cross-examination at our hearing that that was her correct email address. I emailed her and attached my correspondence, and that was not, I received no notice from Microsoft or whoever that it was not delivered. To your question, I mean, it's not my preference, but that was the only way I knew to do it as a affidavit and to attach the other supporting documents that wouldn't otherwise have been prepared or existed had she not communicated that she had no intention to desire it, to oppose the DEC action. In fact, she'd already signed an affidavit in the tort case that Mr. Fisher is handling that says there's no insurance. The other point that I wrote down, I also appreciate the court's question. Yes, Ms. Johnson is an insured person. I don't care whether she was appointed administrator ad litem or not. She would have been the person to receive notice that Tennessee Farmers does not intend to cover this act. And so I don't really care what we call her. If we call her an administrator ad litem, if we call her a surviving spouse, if we call her an insured, this policy does not cover non-accidental happenings. The court asked about the meritorious defense, and the word intent does not appear in the policy. It has to be an accident. If Mr. Johnson on his rampage, if they were to argue that he was cleaning his rifle at each station along his trip that day and that the gun accidentally discharged, then there might be coverage. But absent absent that, there's not going to be any coverage for this series of acts. The other thing I'd like to just stress, and again, the court didn't willy-nilly make this decision. He made us come back and set it for a hearing. So we had witnesses. And so who on the earth is in the best position to observe the demeanor, the candor, and the personality of the folks involved than the trial judge himself? And he specifically, I will also point out, I don't know if the technical record has he actually asked us to submit competing orders, which I think we did, and he drafted his own. The trial court drafted his own order and declared that he did not find, that he found Deputy Thompson to be a credible witness, and that he found that Ms. Johnson was not credible. And understandably, yeah, she had to take a break during her testimony. I'm sure it was stressful. I'm sure it was all traumatic. But that's the very reason why she is not a credible witness. And the trial court made that finding. In this case, there's been absolutely no showing of any abuse of discretion, and we would respectfully request this court to affirm the trial court's ruling. Thank you.
Thank you, Mr. Dix. Mr. Fisher, your rebuttal.
Thank you, Your Honors. Again, some of the stuff that was discussed is not in the record. You had asked if there was a motion to exclude that. There was an objection on the record that was hearsay. What you said that he said that they did everything they knew how. They never sent one of these motions, anything via certified mail. Doing a lot of plaintiff's work myself, that's what we do when we're sent, certainly a motion for default, notices of hearing, so we could show the court, yes, this person got it. Another thing, and maybe in the record, the judge's comments is that he recalls being concerned when he attended the Zoom hearing for the motion for default and wanted to make sure that when he looked at the summons that everything was done right. He said there were concerns, so there's some reasonable doubt there in this case. It is important to know that at the time, Tennessee Farmers had appointed another counsel to represent Ms. Jacqueline Hall Johnson in the tort case. So, and she had an attorney representing her in relation, Matt Potempo's office was representing her in relation to the sale of a home in a chancery court issue. So she has each two attorneys representing her. Neither one of them get any sort of call or heads up from Tennessee Farmers attorney in this case. There's no contact there between any of those parties. And in all candor, when I took Ms. Johnson's deposition in the tort case, that's the first time she ever even heard of the DEC action. And I handed it to her. She'd never seen it before. I handed her the order granting default, never seen that before. And that's when it came about that she wanted me to represent her to try to get that set aside.
Counsel, in Ms. Johnson's proposed findings in this case, did she raise the proper party issue? Are there proposed findings related to the proper party question in what was submitted to the trial court?
What do you mean by proposed findings?
So my understanding is there proposed findings from both sides submitted in this case after the hearing.
Oh, the proposed orders?
Proposed orders in this case. Is there any reference in the proposed order to the proper, with regard to the proper party issue in this case?
I have to look here, Your Honor. I know that it wasn't in Mr. Dix's order.
I didn't know if Ms. Johnson had included anything in there with regard to the proper party question.
I believe it just goes into the service issue, saying that she wasn't properly served is what the proposed order goes into.
But you're not aware of any reference to the proper party question in the proposed order?
Not in
Okay.
the proposed order, no, Your Honor.
Okay.
So, in getting to just lastly, the merits of the issue and the accidental argument, sure, if he was cleaning his gun, that analogy, that works. Did he mean to cause trauma to the person he shot? Maybe. Did he mean to cause the windfall of damages to those that surrounded the person that witnessed their father die? I think that ultimately is a question of fact for the jury in the case, and it should be allowed to proceed forward. Thank you, Your Honors.
Thank you, Mr. Fisher and Mr. Dix, for your arguments. We'll take this matter under advisement. That concludes the docket.